This is, as I was just saying to somebody, this is a subject I don't know a great deal about, so I am as eager as you are to hear from our panelists. And let me introduce them to you. It's another outstanding panel. I'm going to start, again, way over on my right with Andy Crane. Andy is the Vice President of Forensics and Collections at Discovia, and he runs the Forensic Investigation and Data Collection team. His team collects data from thousands of custodians annually, and their reach is both national and global. Andy provides expert witness and strategic consulting services to law firm and corporate clients in the area of computer forensics, investigations, electronic discovery, and litigation support. He is licensed both as an attorney and a private investigator and has assisted clients with a wide variety of consulting engagements. Prior to joining Discovia, he held a number of positions in the litigation field, including forensics litigation director and computer forensic lab director. So thank you, Andy. To Andy's left, we're delighted to have David Cook. David is a senior managing director of Guidepost Solutions, and his work involves the areas of litigation support, internal investigations, due diligence, fraud and theft of trade secret investigations. And even though he doesn't look it, he's got more than 27 years of experience working with law firms, corporations, and financial institutions. And his experience includes cases involving embezzlement, trade secret theft, misappropriation, export violations, stock options, backdating, securities fraud. I am reading this because I enjoy reading this list. This is really wonderful. This is what we all do. Franchise litigation, background investigations of people and entities worldwide in connection with proxy battles, investments, joint ventures, supply and distributor agreements. He is a member of the Oregon Bar, and earlier in his career, he was with the FBI for 8 years as a special agent, legal advisor, and instructor, and was assigned, interestingly, to the Foreign Counterintelligence Unit. And in that capacity, he explained to me that he actually went underground with his family, underground and undercover, for 2 full years, taking on a fictitious identity. So very interesting personal experience. So David, welcome to our panel. To his left, Anthony Pacheco. Anthony comes to us from Los Angeles this morning. Thank you, Anthony, for that, and battling the traffic. He's been a lawyer for 26 years as a partner now at the Jeffer Mangels firm, representing clients in a wide array of circumstances, including criminal, quasi-criminal, civil, regulatory, administrative, and parallel proceedings litigation. He's handled numerous internal investigations and managed sensitive public relations issues. He has substantial experience with wire and mail fraud, securities and financial fraud, cyber crimes, insider trading, campaign finance, environmental crimes, tax, antitrust, defense contractor fraud, healthcare fraud and abuse, bank fraud, and other white-collar crimes. To his left is Chok Wee, and Chok is responsible for managing global incident response programs at Electronic Arts, which is the world's largest video game publisher. And he's the focal point for incident response, and he works closely with EA's corporate security, legal, internal audit, HR, IT, and technology teams. And Chok has 15 years of experience in information security, incident response, and risk management, as well as regulatory compliance. Prior to joining EA, he was a consultant and a systems manager, but most significant to me, because I remember Chok. Chok was a director of information security investigations and incident response at Oracle back in the day. And his team conducted investigations into matters there such as high-risk terminations, security breaches, and information security compliance issues. And that included orchestrating complex computer investigations in a variety of foreign jurisdictions. So welcome, Chok, to the panel. And finally, to my immediate right is Jim Maroulis, also a former colleague of mine in the Oracle Legal Department. And Jim is a managing counsel there in the litigation group, and he focuses on securities and commercial litigation and oversees really any federal securities class action or derivative cases in which Oracle's involved. And that, if I recall correctly, is a few.
It has been.
And he's responsible for DOJ, SEC, and FINRA investigations and inquiries. And prior to joining Oracle, he was associated with the Cooley firm and the Davis Polk firm. So, as you can see, a stellar panel with deep experience on the issues we're going to be chatting about. So, what are those issues? We're going to be focusing, as I said, on an area that I am not entirely familiar with. It is the use of forensics in internal and compliance investigations. So, because I'm not familiar with it, I'm going to start with a very basic question to our panel, and that is, what the heck do we mean by forensic analysis? How does that analysis get used in internal investigations? So inform me and inform our audience. And I'll ask Andy, first turn this over to you for this kind of basic tutorial.
Great. Thank you, Dan, and thanks for everyone for coming. I guess to set the stage for this panel, the topic definition of sort of what is this stuff and how does it get used in internal investigations, I would just say there's an ever-growing list of sort of categories of information and types of data that's typically a little bit beyond the traditional family of sources. You know, over years, the traditional approach has been to look through people's corporate email, you know, maybe some phone records, but now with the explosion of different devices and platforms in the cloud, and the ubiquity of the internet, now there's an ever-growing list of things that can supplement those traditional sources, and those are things like what we typically refer to as private communication channels. So that's, you know, Skype and instant messaging, as well as webmail, et cetera. The prevalence of SMS and IM and all these private messaging channels, of course, made even more difficult by things like Snapchat. You've also got obviously all the internet activity, and as we'll talk a little bit, I think threaded through this panel about investigations that center on misappropriation of trade secrets, and investigation there. It used to be, and I think there's some people in the audience who have been doing this type of work for a while, it used to be they printed it out, and then it used to be they mailed it to themselves, and then it used to be they put it on their thumb drive. You know, nowadays we're really looking to the internet history and the cloud type of evidence. I think that's the prevailing trend I see of how people are moving this stuff around. Of course, social media use, evidence of deletions, document recovery. There's really just an ever-growing list of these forensic types of data that can really help in internal investigations. They can impact you know, interviewees or witnesses' credibility. They can help identify other subjects who might be involved. And I should clarify, I really enjoy the investigative space a little bit more than the litigation space, because in litigation we call them custodians, and in investigations we call them subjects. And I guess just a couple quick examples before I have some of the other panelists chime in is just, you know, I thought back about a few illustrative examples, and in 2013, you know, we assisted clients and their counsel in responding to government investigative demands where the regulators are asking for things like deleted browser history, deleted text messages. This is stuff that you just used to not really see, or I used to not see in government investigative demands. And I have another quick anecdote from a matter early in 2013 where, again, this was sort of a trade secret kind of thing, and they interviewed people and they looked through their mail, and then they got around to doing some forensics, and we generated some really helpful additional clues that, you know, directly contradicted the interview testimony that some of the subjects had given. So it was a tremendously powerful technique for counsel then to basically re-interview those folks. Unfortunately, I did not get to be a fly in the wall as they determined how to phrase, "Would you like to reconsider your answer?"
Well, you know, just judging from the categories of information that you were describing, this is a pretty important subject. We're talking about social media and how do you recover communications through social media, deleted text messages, you know, looking at browser history. I mean, it's pretty important stuff. Is this something we've been able to do before? Is this a new area of investigative work?
I'd say it's just ever evolving. Some of that stuff it didn't spring up yesterday, but as people's computing habits change and the type of things that they're doing, I'd say 5 and 10 years ago, I certainly wasn't including in any of our forensic analysis projects things like social media, whereas now you can't avoid it. So that's the way I'd characterize it.
Mm-hmm. Yeah. And we talked, I think, in the last panel about some of the challenges of collecting that kind of information. Well, Jim, I'll turn to you and ask you, what has been your experience with respect to using forensics in internal investigations and compliance matters generally? Are you spotting any particular trend in how that's going?
Yes, I'm in-house, and so my primary focus is responding to the government when we do get a subpoena or we get an inquiry. And what I've noticed over the last couple of years is a couple of developing trends. Number one, there's an increased amount of SEC interest in insider trading, and probably appropriately so. I think the SEC is getting better at identifying potential insider trading activity, and they're definitely proceeding against it more aggressively. The SEC also is becoming more sophisticated in what they're asking for from companies, and in addition, the Financial Industry Regulatory Authority is also getting more sophisticated. For example, every time we're a company that does a lot of acquisitions of publicly traded companies, and every time we do an acquisition now, within days, we receive a request from the Financial Industry Regulatory Authority, which not only wants to know everyone on our side who had knowledge of the deal before it was announced, but they want the home address of the person. And what they do is they're able to map out the home address of the person who knew about the deal, and then the home address of the people who traded. And they look to see if there are hot spots where people live close together, and that's worked quite well for them in terms of identifying trading. In addition, as Andy pointed out, they're getting more sophisticated in what they ask for. The SEC has been asking for deleted browser history, and it's been something that is a very powerful tool. Earlier this year, we had a case that I worked on with Andy, and the subject of the investigation, on the day he decided to purchase stock in the company that we were going to acquire, did internet searches which he deleted, both for Oracle acquires X Corp, and I kid you not, he actually Googled minor insider trading. That is about the best evidence you're ever going to see for Sienter in an insider trading case. And it was in the deleted browser history, and the government knew to ask for it.
Very interesting. We've come a long ways. Back in the day, I mean, when the SEC was suspecting there was some potential insider trading, they'd just give you a list of names and say, do you recognize any of these names? They've come a long way, too, because they're now using very sophisticated analytics with the help, actually, of many of the companies here in the Bay Area. And they've got very powerful tools. So I agree with you, Jim. I think they really have improved tremendously their ability to really zero in on trends and problems in insider trading, and it is an area of focus for them. Let me ask Anthony, from a prosecutor, or at least a former prosecutor's perspective, about the utilization of forensic tools in investigations.
Well, now I'm a white-collar criminal defense attorney, so I'll have to flash back to the days when I was with the U.S. Attorney's Office. And so the mentality there as a prosecutor is to gather up as much information as you can to give you insight into a particular individual or an organization's thought process, their intent. And anything that they can do to be able to get that information so that they can then see if it's admissible and prove a case, they will. And so with these emerging technologies and developments, more and more the trend is to use these new tools to give insight into individuals' intent, whether it's insider trading or illegal campaign finance or any other type of potential criminal violation. So the SEC is an interesting study, and I think they are on the forefront of asking for a lot of information that's emerging. Right now, what typically when you get an SEC request, it's now you're seeing more and more the request for the wholesale production of forensic digital images. So if you've got laptops, computers, and the like, they're asking for everything on there, and all the metadata and everything else to follow. And I find that to be extraordinarily cumbersome, burdensome, and a problem. And it becomes a negotiation with the SEC to limit it to the pertinent information. But they're not the only ones. If the Department of Justice thinks that your computers or individuals in a company are involved in some kind of criminal activity, and they think that the computers are an instrumentality of that criminal activity, they'll take the whole thing. They're known to take the network in a search warrant. And there is no negotiation except to when you get the materials back, and when you have access to your own network. So there's definite interest by prosecutors who are suspicious by nature. I'm nicer now. And who will take advantage of these newer technologies. You will find them looking at Facebook, for looking at Snapchat, spending some time on Instagram to gather information. Texts now, I think it's old news. They go there and gather that information. So anything they can on the technological front to get an advantage to prove a criminal case or an administrative case, they will.
And I assume that on texting, they have the ability to subpoena the actual carriers who are retaining that information on their servers. So that's available. But what about Snapchat, where the message disappears, in 3 or 5 seconds or 7 seconds, however many seconds you ask it to from your screen? How do you restore that, or how do you resuscitate that kind of information?
Yeah, more problematic. Maybe that lends itself more to the undercover world, where you can
David's world,
where you can send messages and start engaging people in undercover activities in that way. I've had interesting cases where on Instagram, or where people send photos and all that. Where we've sent in undercover folks to engage people and to sort of get photos. It's pretty amazing how, particularly the younger audience, will send out information voluntarily with the right prompts. It's pretty amazing, and then that's nice information to have.
Absolutely. Does the government actually do that?
Chuck,
let me ask you, in connection with the investigative activities that you do within the company, have you ever encountered this challenge of trying to restore these kinds of records?
Yeah, what I can say is, if you're a big fan of X-Files, how many of you watch X-Files and like that show? The truth is out there. Here's the reality: once electronic information gets out of your device, or you create that, it's going to stay somewhere. And the challenge is really to find where it resides, even after deletion. The only thing I can say, if you have a data that resides on a hard drive and you employ a technique called wiping, which is replacing every bit on the hard drive with zeros and ones or whatever pattern that you want that falls within hexadecimal numbers. Sorry if I'm getting too tacky here, so raise your hand if I'm getting too tacky. That will give you some assurance that your information is completely unrecoverable, although I have to say that some three-letter agency out there will be able to use an electron microscope and to uncover those information. So the information is out there. I have come across challenges in terms of finding information that's seemingly not traceable. But with today's, social media, I leverage on that quite a bit. The social media actually gives you a very powerful tool, not only to uncover information, but also to be engaging with the subject under investigation. Any social media to just name it, somebody is going to be somewhere. So back again, the truth is out there.
So are you saying that if you are doing an investigation and the subject has, say, a Snapchat account, that just the fact that they have an account prompts you to pursue this by engaging them in conversation, potentially? I mean, if you, depending on how deeply you want to go, but because you're not going to see any evidence of messages, but you know there's an account. I mean, what do you do?
So one thing I always preach to my guys is, if you are in this profession, you need to think outside the box. That's number one. Number two, you need to be creative. And the mindset for forensic investigator, is very different from mindset of a, say, traditional investigation. You have to look at technology and be able not to only understand technology, but also to understand where the footprint might be, the trace of the artifacts of those information might be. But at the end of the day, when you have found the information and you have found the breadcrumbs, there's one thing that I always emphasize to my guys or to anybody that's interested in this topic, is take a look at this document called ACPO. It's from the Association of Chief of Police Officers. And it basically outlines 4 principles about forensics. And the 4 principles are very important because it establishes defensibility. Okay? This is a document that's produced by United Kingdom Chief of Police. I encourage you to look at it. The first principle say you shouldn't alter the evidence, original evidence. And the second principle says if you have, in the event, you have to alter or access the original evidence, you must be able to explain and document the action and why certain things happen. The third thing is audit trail. You must be able to document, and it must be repeatable by a third party, and the outcome or the result of the finding should be the same. Number 4, the 4th principle is the one that I like the best. Whoever is in charge, or whoever you delegate this task to, must be able to enforce the first 3 principles. As a manager, I love that principle, so that I can delegate to anybody, but I'm still accountable at the end, I guess. So I would highly encourage you to take a look at that. The reality is sometimes you don't always win, especially when you're dealing with high-tech companies, such as Oracle, Facebook, Google. You have a lot of smart guys in the company that is going to be smarter than you are in terms of covering their traces. So at the end of the day, don't feel bad if you don't find the smoking gun.
Well, that certainly is revealing. What was the name of that, ACPO? What does it stand for?
ACPO stands for Association of Chief Police Officer. Make sure you go to the right website and don't download the file, the PDF file that has malware in it. So I highly encourage you to take a look at that document. It's one of the many principles and guides that you can refer to. There's a lot of principles out there. But I think at the end of the day, I like this the most because it is so simplistic. The only problem that I can see about this document is written for law enforcement. So you're going to see a lot of wording such as agent, those law enforcement terminology. Translate that to layman's term and apply it across the organization.
Jim, did you want to add anything to this?
Not specifically to the points that Chalk was making.
He did refer to this as a profession. You heard that?
Yes.
And I'm very interested in that because, you have these ACPO principles. Are there standards here in this area that forensic investigators adhere to? Anthony?
I'm sure there are, but I look at it from the defense counsel standpoint, and I look at it from an admissibility of evidence standpoint. And that is, do you have the right testifying witness available? And shockingly, a lot of times in the gathering of data, particularly in emerging technologies, you don't have the right custodian. Or, and there's new Supreme Court cases in this area where either the government or opposing parties try to get summary witnesses to come in and testify. And they get knocked out because they're not really, they get knocked out on constitutional confrontation grounds, because you really need folks to testify who know about the particular gathering of the material. So a lot of times in these emerging technologies, you'll have data compilations, and you have the wrong experts, and you really want the individuals beneath it who were participant in gathering the information to testify. And that's how you can pick apart the other side, by talking about these individuals who know slices of a pie on a compilation, but don't know the totality, and yet you can't bring in the summary witness because you don't have the underlying correct testifying parties. So with the emerging technologies, I find it difficult from an evidentiary standpoint. You might find these leads, then what do you do with them? And are they admissible, and how do you get it in front of the court? How do you survive Daubert tests for the reliability of this emerging technology and the science relative to it? So those are the challenges that I see relative to once you get the information and you're planning to get the information. How do you use it in court, or how do you convince a prosecutor with it that it's going to be admissible if you're voluntarily disclosing, saying, hey, we really got some information for you to use?
No, that's a great point. Well, David, we're going to come back to you now, because we've talked about the use of computer forensic techniques, but those are not the only techniques. They really just supplement internal investigation efforts. You've had a very long and distinguished career in this area. Could you describe for us some of the other techniques that are often used in forensic examinations or investigations?
But I'll start off with the ones that cause the most trouble or keep GCs up at night. Probably one that we've used in trade secret cases, and this is usually prompted by software engineers who are about to leave the company, that during their exit interview say, you know, I'm going to sit on the beach, I'm going to go to Hawaii and take some time off. And you know darn well that's not what they're doing. What are they up to? And this gets into some privacy issues, but surveillance is one of those techniques that's pretty straightforward. As Yogi Berra said, it's amazing what you can observe just by watching. So in a long, drawn-out trade secrets case, I won't name the parties involved, but it was about 10 to 12-year battle here in the Valley. We took the client's software engineer to a business park, and we couldn't figure out why he was there, and he kept going into this one particular office. Well, it turned out that this office was leased by the head engineer of a competing firm, and that's where they were meeting. So we actually rented an office next door, and then in the hallway put in a camera that would sort of track this person's comings and goings. That was a great case also because we got some good shots in the parking lot of somebody handing over an envelope. We have no idea what was in that envelope. But the law firm client said, you know, I want photos. This is going to have great jury appeal. And then I said, well, I'll get you some nice clear photos. They said, no. We want things that look grainy, you know, those sort of film noir, if you will. We had another case for a major sports franchise where they had someone in their department purchasing and dealing drugs to the players. And we put this person under surveillance. They were driving fairly fast in the East Bay, took them to an area of Oakland where the only thing you really do is to buy drugs, and documented that. And then on the next weekend, we followed him to a wedding reception that he attended at a private country club. And we were in a public place, but a camera focused on the parking lot, and literally saw bags of cocaine in the front of the car. And then players coming out and purchasing that. It's interesting, he was terminated and his defense was wrongful termination, and he made the interesting argument that this was a violation of the Fair Credit Reporting Act, opening up an investigation on an employee, essentially not notifying them of it. Well, there are a couple exceptions. One, if you think there's an ongoing crime being committed. But he also said that we endangered the public because, after all, we had kept up with him when he was doing 95 miles an hour on 580. And the judge kind of threw that out and said, surveillance is a fair game. The other one that would keep Dan up is known as dumpster diving, or as my British colleagues like to say, black foresting. It just sounds better.
Curbside evidence retrieval.
That's another good one. Good one. And again, you have to ask a couple of questions. So one is what we call the Wall Street Journal test. Given that all your activities and your methods are legal, how would your client like to read about this activity in the front page of the Wall Street Journal? So while it's legal from a PR standpoint, it may not be the greatest. You've got to look at privacy issues, obviously, anywhere from state privacy issues to local ordinances that prohibit you from collecting trash unless you're with a sanitation company.
Or union.
It can be an extremely valuable tool. One that I'll mention was I worked with Gary Weiss at Orrick Harrington, and the client was Applied Materials, and they thought one of their employees was feeding designs to a parts manufacturer. And sure enough, this is 15, 20 years ago. He actually had me do the dumpster diving, and I said, it's going to cost you less if we have somebody else do it. He says, no, David, to your point, you're collecting it. We want you to testify. So I spent many nights in this dumpster, and we just found great stuff. I mean, memos and faxes and copies of designs and so forth. And I've always told, the litigation people, I said, this doesn't work every time. And Gary will admit this, it became like heroin to him. He thought this was the technique to use on every case. It was wonderful, except, the downside is that when you're in a dumpster late at night in San Carlos, watch out for the firms that allow people to have pets at the office, because there's nothing like standing in a dumpster at night and somebody dumps a cat litter box. Or if you're dealing with a company and there's bio-waste, or if there are gangs around the area and you're sitting in the dumpster, very quietly for 15 or 20 minutes. We had one case for a client that had a major judgment against a gray marketer, a counterfeiter of product. And he claimed that he was going through bankruptcy and couldn't satisfy the judgment. We found in the trash shredded documents, which the old-time shredder, the strips are about like that. We put it together. We found bank accounts in Luxembourg. And we also found him trying to hide his real estate assets. It was so funny. English wasn't his first language, but he was trying to fabricate a grant deed. And he kept spelling it grand, a grand deed. I'm not working against rocket scientists out there a lot of times. There was a recent federal conviction of someone on a trade secrets case. We had done the underlying work, but it's an example of you can't get their private email, but if they're visiting their girlfriend or their mistress and they have this habit of printing out, and some people do this, print out all their emails and then toss them out, that's also fair game. And then the established technique, there's nothing proprietary about it, is public records research. And this, everybody thinks they can do this because they use our proprietary database called Google. But there's a real art to it. And one case, we were trying to find a corporation that we thought a subject had, and actually never incorporated it, but it was a fictitious business name. And it's a company started about 7 years ago. Turns out that company is a vendor of his employer and the clients. And he was basically ripping off our client with that. The last thing I can talk about quickly are interviews. Whether, it depends on what the type of case you're dealing with. Is it an informational interview or a confrontational interview? What's the right chemistry? Do you have outside counsel conduct these interviews with the investigator? Do you do it with general counsel? Do we do it with HR? The key thing here for interviews is preparation and really micromanaging the setting and what your goals are and what the psychology is. On some cases, and a former colleague out here will attest to it, we've brought in behavioral psychologists to basically assess and do a profile on the person we're interviewing so that we have that sort of edge. And then there's the old, good cop, bad cop routine. And as John Kecker told me once, it's not good cop, bad cop, David. It's bad cop, worse cop. But one of the things I find very important is if you're going to interview somebody and you're presenting them with electronic evidence, and it's good to have absolutely two interviewers, one that really knows the technology and can follow up on it in a Q&A setting, and the other one that sort of knows the overall investigation. I'll pause. I've spoken enough.
No, that's great.
And Dan,
Chuck,
I would
did you wanna
just
add
Yes,
something?
I actually like to add something to that. I think, even though I do computer forensics as a profession, I think by and large, there are techniques that David just described, which is brilliant. You don't even have to go to do computer forensics in order to get your evidence. The best evidence, and this is a cliche, best evidence is a confession. And I'm going to paint you a scenario. Imagine an office. Imagine sitting in it. I'm there with physical security. This individual we call the subject was invited into the office. I have a stack of binder this thick. And when he sat down, I explained to him, we uncovered a lot of information on your server that's inappropriate. And I open up the binder. I show him the first page. And I say, would you care to explain the rest of the pages for me? And guess what happened? He was frozen, silent, and the next sentence that came out from his mouth is, all those movies that I uploaded to be shared by my colleague, I didn't mean to infringe on copyright law, blah, 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 blah. Do you want to guess what my page 2 to page 100 is? Blank. It's blank. I only need the first page. So,
Clever
Yeah.
guy.
traditional investigative technique, I'm a big fan of that.
We would never resort to such trickery.
I'm starting to get that impression. I want to come back to this word profession. All right, I'm going to go around the panel with a broad question I'm going to pose to all of you, having heard from David. What are, from your perspective, what are the biggest risks today and the biggest challenges that you've encountered or are encountering in your own practice regarding the use of forensic analysis in internal investigations? And maybe, Andy, I'll start down there and we work our way up this way.
Sure, and before answering that question, Dan, I was just going to make a quick point to follow on David and Chalk's comment there about the use of forensics as a supplement to sort of traditional techniques and some of these techniques that David is talking about. And at risk of stating the obvious, some of the most productive results come through a harmonious blend of all of those. So, for example, and I know what some of these stories that David's telling are. Things that names, companies, individuals, things you get through surveillance, little tidbits you get through the dumpster, that becomes a search term for forensics, or vice versa. Leads or clues you got in forensics that you don't exactly know where they lead or what they mean. Those are key ammunition for the interview planning. So it's really the blend of the techniques, in my experience, that's the most effective. To turn to your question, Dan, about risks and challenges, a couple quick things come to mind. First and foremost is just in today's changing sort of corporate environment, the very significant physical and logistical challenges at getting at the data and the data that you need. You heard about this in the first panel a little bit with bring your own device and cloud. It's not always an easy undertaking now, especially in investigative scenario where we don't just put the person on hold and say, can you bring your laptop to the conference room at 2 o'clock like you do in Discovery? You know, this subject, you gotta come up with sometimes some pretty significant pretext to figure out how to get access to that machine. Those endpoints of phones and tablets and laptops, those are the ones that contain all the real nuggets of user behavior. That's where you're going to get that private communication stuff. That's where you're going to get deletion. That's where you're going to get all their activity from. And so in today's sort of changing world, that is an ever more challenging undertaking. You know, you've got remote employees, and sort of to couple on that point is, you know, when I first started doing this work, I don't think any of our corporate clients ever had encrypted computers. And now easily over half of them do, and it's an ever-increasing number all the time. So, you know, we can usually surmount that or bypass it, but it sometimes limits our methodology or changes our approach. So that's another challenge we're dealing with. And then something I mentioned in the opening comments, just the proliferating sources of information that you would need to go to. People have got, I think the gal from VMware talked about, they sort of almost encourage culturally the proliferation of devices. So it's not a situation where it's a one custodian, one subject, one computer ratio. He's got his tablet and he's got 3 phones and he's got the home computer that can VPN in, and it's quite a lot of stuff that you might have to address. And then the last sort of challenge or risk I'd highlight, Dan, is something Chalk mentioned, which is the disk wiping and permanent deletion utilities. Kind of like what I mentioned with encryption. When I started doing this, it was very rare to come across people that had wiped or used permanent deletion utilities to clean up tracks. Now, very, very common. You couple that with private modes of browsers, and certainly something like Snapshot. This is getting harder, not easier.
Interesting. David, did you have anything else you'd like to add?
I think Andy makes a good point. Sometimes it's just the simple logistics. Is the person under investigation, subject or target, whatever you want to call them, are they bringing their computer to work every day? Are they bringing it to work the day that you're going to seize it? And we've had, and there are different scenarios. So we've had cases where we might have somebody under surveillance just to see if they're bringing their laptop or what their route is into work. I mean, oftentimes you hear the excuse, where's your computer? Oh, well, it just fell out of my car or my car was broken into. So we can help on that. We had one case where we had access to a computer at a home, but we had to get it apart and make the mirror image there. And I think I can't remember what type of computer it was difficult to get into. So we put the subject under surveillance, thought they were going a long distance, and all of a sudden they did a U-turn. They forgot something at home. So we had to it was like a mission impossible. Everybody sort of dove under the bed and in the closets, and we went at it later on. I'd say a couple of the risks or concerns I have, challenges, is limiting people in the company who know about the investigation, protecting the confidentiality, and safeguarding the reputation of the employee that is under investigation. It also, I think the more you keep it confidential, it enhances other witnesses coming forward or other employees that you have to interview. And it also allows you to keep running your business without everybody being distracted by some confidential investigation that no one's talking about. The other challenges, oftentimes companies weighing with their general counsel and their outside counsel whether or not to refer it to law enforcement. And sometimes it's an issue of, it's the only way they can get their confidential data back. And once you make that referral to law enforcement, you're really losing control of the investigation. And in some cases where the government has worked on an expedited basis, which is different from what the private sector means by expedited. If they serve a search warrant, they've invested a lot of time developing the information for the search warrant. They don't want a lot of people to know that this search warrant is out there. So I was working for a big company, huge company, and the general counsel said, well, I need to give a couple of our senior vice presidents heads up that this is going to happen because this is going to hit the media when this guy's house is searched, et cetera. And I remember the district attorney asked, well, how many people we're talking about? And he said, just the top 60 or 70 vice presidents. They quickly got on the same page, and we kept the circle fairly close.
Anthony?
Well, we live in very fast times. The technology and developments blazing ahead. We have a time where new legislation and the government demands that companies quickly self-report and come in and handle matters. And against that backdrop, to me, one of the biggest challenges is, as counsel, outside counsel to companies, how do you comply in these fast times with and meet with regulators and DOJ and make statements about what the matter's about, and what you found, and how do you self-report when information that may be obtained later in the investigation is going to contradict you and stand you on your head, particularly maybe about executive misconduct or machinations that might be going on in a company. And does that later then not only sour the prosecutor, but does that piss her off so much that she'll consider obstruction charges or witness tampering or other issues that really make a criminal case kind of sexy? And so it becomes a real problem in these fast times where you're expected to really get your arms around things quickly and understand things, and then things will turn out differently. Hypothetically, because I have amnesia about the names of any of my clients, but hypothetically, just imagine an in-house lawyer or a compliance person who's unhappy and is terminated and knows so much about your organization, and that lawyer or compliance person then turns on the company in some kind of an employment dispute, and that lawyer knows all about who at that company's on Facebook and who's sending Instagrams and who's a texter and who's not, and will start and maybe they USB'd a lot of that information themselves, and they're taking that information to the government, not thinking about their bar license or any of those circumstances, and that information then later contradicts how you've presented the company to the regulators or any other skilled or sophisticated whistleblower. That can be a very bad day, and so you have to try to guard against that and do your best to slow things down to assure yourself that you're getting all of the right information. And sometimes making it even more complicated is then you're getting pushback about the extraordinary costs, and understandably there's some pushback, extraordinary costs about gathering that information. You know, hey, Mr. Outside Lawyer, you're making a mountain out of a molehill. Why are we looking at all of these things? Why are we spending this expense? What's going on here? It's because you've seen the movie previously and you know the bad outcomes that can occur. So to me, that's the biggest risk and challenge in this area of these developing, quickly emerging technologies.
Anthony, I have one question I wanted to ask you. It has to do with whistleblowers. I mean, I've had the experience myself where a whistleblower oftentimes was the very person responsible for the wrongdoing that was reported. And if you as the company are conducting an internal investigation about that wrongdoing, you compile all of this forensic evidence, whether it's the skullduggery that David is describing or the computer forensics or that kind of thing, and you happen to come across the fact that this person now is a whistleblower, that hey, you come across communications where he's reported it to the government, how do you avoid the anti-retaliation provisions? I mean, you know, you're conducting this internal investigation, you're identifying wrongdoing, and yet now you're seeing that this person actually has reported to the government. What do you do?
Well, sometimes it is a bit of a race to the regulator. If you know a whistleblower is coming, sometimes you want to be in the door first. And so, but I think you're talking about a circumstance when you're not first in the door.
Right.
And, you probably ought not fire that person. You know, you may consider options like putting them on paid leave. You're certainly going to want them not to have access to your network and your systems, and try to eliminate their ability to talk and interview and gather more information from key players in the company. It's a delicate, difficult situation. You may want to go to the regulator yourself and talk about some of that information and may not be particularly comfortable, but you may want to cast that person as a bit of a rogue in the company if that is in fact the case, and let the prosecutor know that's the case, and let them know about the injustice of having a person create havoc and then all of a sudden then try to benefit from it. So I think, the labor implications are very difficult in that circumstance, but you're not powerless. You still have obligations to investigate and to investigate well and to move forward with your own investigation and then make your decisions about how you handle that information relative to the either the regulator or the Department of Justice.
Yeah, and ultimately, it seems we can't lose sight of the fact that the key objective here is to stop the wrongdoing.
Right.
And that's, I think, what has to be borne in mind. And if that requires putting the person on administrative leave just to get them out of the company, then you need to do that.
Right.
But you need to take corrective action as soon as you learn about the wrongdoing so that, it doesn't continue. Chalk, do you want to chime in a little bit on this issue of risks and challenges?
I can talk for days about risks and challenges, but I won't bore you to death.
Would you speak into the microphone?
Oh, yeah, sure. I won't bore you to death about, the 2 days of recent challenges I have in my mind, constantly spinning, keeping me up at night. What I will do is I will let you know that whenever I look at risks and challenges in computer forensics, I always look at it from the perspective of information security. I'm, by training, is an information security individual. So when I look at some of the risks, I'm really looking at, okay, if I were to be able to do, let's not talk about the other part of computer forensics. Let's just focus on preservation. You're trying to take an image of a piece of information that potentially could be evidence to build your case. Now, the preservation has to be done in a very, defensible manner. In order to do that, I think one of the risks is what I call is the unknown. Because simply, things like bring your own device to work, the clouds, and different ways of storing information these days, if you don't know where your data is, you can't manage what you don't know. So you can't preserve. That is the number one risk within your organization. Now, how do you overcome that? Well, my past experience is working with procurement. Those folks will be able to tell you from procurement perspective, if they have a process, a rigorous process, where are the internet lines coming in, what kind of machines being brought into the company, work with the expense team to figure out who's been charging information asset to certain credit cards. That's how you can identify those assets. The other risk, obviously, is in terms of preservation. If your company hasn't adopted any encryption technology and you're in the process of adopting that, I recommend you get involved upfront at the onset of that project, because it's very important for you not only to protect the information for your company, but also under the circumstances where you've been served with a subpoena and search warrant to be able to produce the information. And if you don't have a good key management and control over those decryption keys, you're going to be in trouble. So those are, the major risks for me. The last one is sort of something to think about, to ponder about, is we don't live in silo today. We have a lot of business partnership and all that. And sometimes the information doesn't reside within your organization that you're looking for. It actually resides with your partner. So think about vendor security standard. What do you want them to be able to put in place as control? Whether it is administrative control, technical control, physical control, that will help you in your computer forensic activities. So,
That's some great topics there. Jim, what about you?
I think I can identify 4 major areas of risk that I'm concerned with. For the first is just too much data From this discussion of computer forensics and all the wonderful stuff you can find in the empty space, it sometimes creates the mistaken impression that we should always be looking in the empty space of everybody's computer, and the government can sometimes ask for that. But bear in mind, if you're going to take a forensic image of a computer, you're copying every single file on the computer. You are copying the operating system of the computer based on the theory that maybe someone's going to hide some piece of information in a system file as opposed to in user-created data. And in many instances, that isn't necessary. When you have the subject of an insider trading investigation, sure, that person should have their computer forensically imaged. But when you have everyone else who's working with this person, generally you can rely on the fact that their user-created data is probably what you need. And if you're collecting from 90 or 100 custodians, your costs can go up very, very dramatically. In addition to too much data, in that regard, there's too much data requested by the government. Like Anthony, I've had the government request in SEC actions entire bit-by-bit copies of the subject's computer. The problem there is that that computer may also have privileged communications, and that computer may also have trade secrets or very important commercial information on it. And that stuff is subject to a FOIA request. And you have some FOIA officer at the SEC who's going to make a decision as to whether it really is or is not confidential. And it takes a lot of hand-holding and working with the government to explain to them that while you're willing to make a forensic image of the computer, and you're willing to search it, and you're willing to share your search terms with them, and you're willing to let them modify the searches, you're not going to give them that forensic image because you can't do it. And quite frankly, they're not entitled to it because the SEC's stated position is that they do not ask you to waive privilege up front in investigations. They used to, they got in trouble for that, and now they don't do it anymore. So that is the too much data problem. There's also the whose data is it problem. And that's just the question that we've been grappling with about people bringing their own devices to work, people sending things to their home email accounts. And you've got to be very careful when you're dealing with the government to explain where you're going to look and where you're going to collect and where you're not going to collect. And this came up recently for me in another insider trading case where we had an employee who was sending confidential Oracle documents to her Yahoo email account. And I can't collect the Yahoo email account. She shouldn't have them there, but I can't collect that account. And I had to have kind of a difficult conversation where after giving her the Upshawn warnings and saying to her that I wasn't her lawyer and I couldn't give her legal advice, I at one point said to her, you have to understand, however, although I'm not your lawyer, that the government is going to expect you to preserve everything on your Yahoo email account and everything on your home computer. And if you don't, you could potentially face criminal liability, and you may want to talk to your lawyer about that. And the government ultimately asked me whether I had so instructed that employee, even though I wasn't acting as her lawyer, and I shouldn't act as her lawyer. And I was happy to tell the government that I did exactly that. But it's a gray area that we haven't faced before, and that creates some difficulties. The next one in which we've touched upon again and again today is the problem of foreign custodians and confidentiality of private information in foreign countries, which may be protected more than it is here. And I've been on the phone with senior folks over at the Financial Industry Regulatory Authority who, as I mentioned previously, asked for home addresses of every single employee who knew about a transaction before it was publicly announced. That's private information in some foreign countries, and you have to get the custodian's consent. And I've had folks at FINRA tell me that even though it would be illegal to force these people to hand over their private addresses, that FINRA expects us to provide that. And if they refuse, FINRA still expects us to provide that. So who are you going to, whose laws are you going to violate? Are you going to violate the laws of a foreign jurisdiction, or are you going to piss off your regulators who are demanding that you give them that information?
That's a good time to take that issue to court and make FINRA state that position publicly in court documents.
Yeah, they were positively gleeful on the phone. The guy was laughing. He was saying, "Yeah, I require it even if it's illegal." Ha ha ha. I didn't find it terribly funny myself.
Yeah, that would change in federal court.
Oh yeah. And then finally, there's the issue of changing data, and I'll have to leave it to folks like Chalk and Andy as to how to deal with this. But you have a website or a Facebook page, and the data on it is changing all the time. When do you collect? When do you recollect? How do you capture all these different changes that have been made over a period of time? And that can be very, very difficult.
Well, we've covered now at some length what this topic is all about. That is, what is forensic investigations, what are the different types, and what are the tools, and what are some of the pain points. And now I'd like to turn the discussion to maybe the messages panel that you would like to leave with this audience about how to prepare for a forensic investigation, or what steps would you recommend a company take if they are about to engage in one? Anthony, best practices.
Companies have to be careful how to use all of their available resources in handling internal investigations. What do I mean? I think companies have to be smart about how to use in-house lawyers for the investigation and how to coordinate those efforts with outside counsel. Sometimes in interviews it is helpful to have in-house counsel present. Sometimes it's not. Sometimes it's helpful to use the IT folks in a company to assist in gathering information. At other times it's not, depending on who's going to testify and the backgrounds of those particular IT folks and their skill with some of the information and handling of it. The way to control a lot of this is to have a very strong presence in a particular company who can make decisions and work closely with outside counsel to make those decisions about how to staff a particular investigation and how to end with the most independent people so that it presents well if you do have to approach a regulator later in terms of a disclosure. I think so many times at the initial stages, because these things can happen so quickly in response to a subpoena or a search warrant or some other difficult time-sensitive event, I think what ends up happening sometimes is that it's not that out at the beginning stages and the planning doesn't occur. So it just becomes a hodgepodge of activity that's sometimes at odds, and then it's really hard to reel it in. On the last panel, they spoke a little bit about budgets and those kinds of requirements. I think money matters, and I think costs matter. So I think it's smart at the beginning to put people on pretty stringent budgets and understanding that things can change and understanding that things sometimes are just expensive. But I think if you take those initial steps, it will make it a little bit easier in managing effectively internal investigations. And I think it's one of those things where there's a certain point too where you have to sort of figure out where you've got these things can go on forever, so you have to have some idea of what your endpoints and your goals are, and when the madness stops and when you've done enough. And sometimes that's a hard calculus, but it's something that you have to think about.
When is enough enough? Chuck?
Well, first of all, I'm not an attorney, so I don't want this to be construed as a legal advice. And therefore, I'm going to say this in a very philosophical manner. There's two things that you should take away from this, or I recommend you take away from this event, is one, you need to recognize your limitation. You need to recognize, as a company, what resources you have, what are the qualifying people that can actually do forensic activities. And if it's a conscious decision, and it's also a business decision, there is a cost associated with running a forensic program. And if you don't have the right person that's qualified to do the work, you're setting yourself up for failure when that person takes the stand in the court. Okay, that's number one. So be humble enough to say, I'm not the expert, let's hire some good guys to do this. The second thing I think I want to say is collaboration. In order to make a successful case, it takes a strong and broad collaboration across the organization. I work with Jim Morales a lot, and I go to him because I know nothing about the law. He tells me, Chuck, you're way off. Okay, and I say, why? Explain to me. And he'll spend 5 minutes explaining. I say, okay, I get it. I won't ask you the same question next time. but I did. So go to the expert, the subject matter experts. There are attorneys within your company that knows about contract law, who has relationship with government agencies, who knows about privacy law. Those things are all very important stuff when you are trying to do a preservation outside the United States, especially in Argentina. Argentina is one of those countries that people think, they don't have really strong privacy law. Try conducting tree preservation across 3 different countries, 3 different time zones, all at the same time under a COVID situation, and one of those countries is Argentina. So I rest my case.
Jim?
First of all, Chuck never got anything wrong, and I didn't have to explain anything to him. But as someone who responds to government investigations, I can tell you that the golden rule is that your relationship with the government is everything, and you've got to make sure that the government knows you're cooperating and the government truly believes that you are going to get them the information that they require. If you lose that, then you are in great trouble and you're going to have massive expense. And in the same vein, if the government does trust you, then don't ever underestimate your ability to educate the government regarding what it is they really want. They expect you to be the expert on your systems, on what's out there, and Chuck mentioned it's very important to know where your data is and how your data is stored, and if you don't know that, there's not a whole lot you can do. But if you are an expert on that, and if you can give a cogent presentation to the government about the way you store your data and why they want this type of data and not that type of data, you can vastly limit the expense and the exposure that you face. For example, the standard letter that you get from the Department of Justice tells you to preserve disaster recovery backup tapes. Oracle has never restored disaster recovery backup tapes, not even once. And if we did, all it would give us is a picture of what our system looked like yesterday, okay? If I've got a copy of someone's email, there is no reason whatsoever to have another copy from the disaster recovery backup tape. And it would cost hundreds of thousands of dollars or perhaps even millions of dollars to restore the disaster recovery backup tapes that we have. If you sit down and hold the government's hand and explain everything to them, explain why it's unnecessary and why they've got the data that they're going to need, you can get them to agree to that. If you don't have that level of trust or that level of knowledge of your systems, the government's going to say, you know what, we're the government, I told you to restore it. And then you're in a real box. So to me, in terms of dealing not with an internal investigation, but with that is pre-subpoena, but with a government investigation, my number one takeaway is to establish that relationship and be very transparent and very responsive and really know your systems.
Excellent. Geez. Great pointers, guys. I'm going to ask Andy to kind of wrap us up here with a summary of, Andy, your perspective on best practices.
Sure. One of the ones I was going to say, Jim just said, so
All right.
I'm out of luck. No, Troy mentioned this in the first panel, and Jim mentioned this. In my experience, I have yet to see an example where the government was unwilling to negotiate about the scope and the specifics of the demand and the response. And in some of the examples, the difference between where their demand started and what we ended up doing was really, really remarkable. So preparing yourself and really taking that step as it sets the stage for everything else that's going to ensue really can't be emphasized enough. 2 other quick points. One, sort of on the information management front, you've heard today about bring your own device and cloud and proliferating sources. I think companies have a real hard thinking job to do right now that fits in with their culture about how much of this stuff do we allow, how much of this stuff do we prohibit or regulate by policy. I think some people in the first panel talked about just the cultural differences between a financial or healthcare company and a technology company. You just can't go into a Facebook or a company like that and tell them you get Dell laptops, you're not allowed to use thumb drives. It's just not going to culturally work. Other places that might work. So each person's going to come out a different place, but the more of that stuff, the more freewheeling and free that environment is, the more complexities you introduce into these investigative scenarios. And so everybody's got to really think through where they come out on that and do things that make sense. And then my last point is just, again, this is going to sound a little obvious, but coming out of countless case examples where this presented huge problems is people make a lot of information management and IT environment decisions based on the costs of storage or licensing, things like that. They often don't consider the eDiscovery or investigative impacts of some of those decisions. So an example is I helped a company last year with a response to a treasury inquiry. And they were quite delighted that they said, you don't have to copy our computers because everything, we're a Google Apps shop, and everything's up in Gmail. But their strategy, like you've heard some of the outside counsel folks talk about today, was to sort of head the subpoena off and to engage the regulators to go make an affirmative offensive presentation to the regulators to essentially try to head off the need to do a full-blown document production. And they had gotten the government to agree to that audience, but it was in like 5 days. And all of their custodians had 20 and 30 gigs of email stored in the cloud. And if anybody's had to collect corporate Gmail out of the cloud, it's a bit like draining a reservoir out of a drinking straw. We just simply couldn't get our hands on the information fast enough to then put it through searching, processing, review kind of steps to empower the lawyers to do what they needed. And the company was probably quite happy that they were only paying, $20 per month per user to satisfy all of their email needs, but it presented them with a very unforeseen challenge when they came across an investigative scenario. I've seen the same problem with archiving tools, bypassing encryption that they've put in. You make all these choices, but you need to almost conduct a dry run or be prepared to work within the confines of those decisions that you've made before the really rush, oh no, reactive moment arises.
Well, that's great, Andy. This has been a great primer for me about this area of forensic investigation. So we started by talking about what it is, defining the terms here and setting the foundation, and then moved to talk about some of the risks of using it, some of the challenges, some of the pain points, and then concluded here with some of the best practices. So if you would please join me in thanking our panel.